There we go.
The Child's Advocate is a project, a special project of Legal Aid of North Carolina. And it was originally founded by Sally Shear in 2009. And in 2014, the Child's Advocate became a part of Legal Aid. So what we do is we are appointed by judges in Wake and Durham counties in family court to provide direct representation to children in contentious, challenging custody cases. And we have a very robust team of pro bono attorneys, and thank you to any of you who are watching this, who assist us with the increasing volume of cases that we are receiving. We are receiving a lot of appointments, particularly in Wake County, but we are looking for pro bono attorneys to assist in both Wake and Durham counties. And one way, if you would like to assist, a quick plug for an upcoming CLE on March 30th at Poynter and Sproul, we will be doing our annual live training for pro bono attorneys from 2 o'clock to 7 o'clock. And so we hope to see you there. Let me turn to my colleagues to introduce themselves.
Thank you, Suzanne. My name is Atia Mosley. I am a supervising attorney at the Child's Advocate. I have been at the Child's Advocate for about 5.5 years now, and I've been at Legal Aid for about 17.5 years now.
Hi, everyone. My name is Athena Hinson-Voigt, and I am a staff attorney with the Child's Advocate. I was formerly an intern back in 2020, and I'm happy to be back serving this mission and assisting our child clients. And I'm excited to be part of the team.
So we're going to basically guide you through some of the ethical rules that are involved in our daily work representing children. We deal with these ethics rules all the time, and Atia is going to go into more detail.
Sure. So there are a handful of rules that we go back to again and again. The first is our TCA appointment order, and the appointment order itself is a standard order that we use for all of the appointments. The appointment order actually references the rules of professional conduct. And so all of the attorneys, whether it is our staff or pro bono attorneys, we are ordered to follow the rules of professional conduct as we represent children. The next is the 2012 Formal Ethics Opinion, number 9. That opinion really helps to distinguish the difference between a child's attorney and a best interest attorney. I'm going to read the distinction between those two that come from the ABA standards, which I'll talk about in a moment. A child's attorney is a lawyer who provides independent legal counsel for a child and who owes the same duties of undivided loyalty, confidentiality, and competent representation as are due an adult client, versus a best interest attorney who is a lawyer that provides independent legal services for the purpose of protecting a child's best interest without being bound by the child's directives or objectives. And you'll note that both of those attorneys are independent, but neither is neutral. People sometimes think that we're neutral, but we're not. We are following our client's position. As already stated, we have to follow the rules of professional conduct. And then another set of rules that we follow, which is really helpful, comes from the American Bar Association, the section of Family Law Standards of Practice for Lawyers Representing Children in Custody Cases. And our 2012 ethics opinion actually pretty heavily cites those standards. And so that's generally the body of law that we are looking at as we guide our work. And the standards provide for good practice and consistency in the appointment and performance of lawyers for children in custody cases.
Great. So now I'd like to ask Atia and Suzanne some questions. To start with, okay, you've been appointed to represent a child. Can you describe what your role is and how you know what your role is at this point?
Actually, I think you were going to go first on that one.
Yes, so I previously read the role based on the ABA standards, and we have clarification, first of all, in our appointment order. It makes it very clear that we are attorneys in the same way that I was an attorney for adults before I came to the Child's Advocate. We have a traditional attorney-client relationship, and we have to follow, we have duties of loyalty, duties of confidentiality. And so it's very similar to all of you out there who have represented adults, parents. We follow that same model in that respect.
So one of the big differences, I think one of the easiest ways of understanding our role is that we are not guardian ad litem. And so the ways in which we are different from GALs is we don't do a report. We don't either do a written report or we don't do an oral report. So if a case goes to trial, we advocate just like the parents' attorneys, if there are attorneys in the case, just like the parents' attorneys act in the courtroom is how we act as the child's attorney. Also another significant difference or a best interest, I'm sorry, between a GAL and a child's attorney is confidentiality. As a child's attorney, we are bound by strict attorney-client privilege, confidentiality in ways that a GAL is not. For example, if a child tells something to a GAL, the GAL is not bound to keep that confidential from other people the GAL may interview. Whereas with the child's attorney, we are not allowed to share anything that the child has told us unless they specifically authorize us to do that.
Great, thank you. So now that you understand what your role is, you are ready to meet with your client and begin your investigation. How do you figure out your client's goals at that point?
That is a really, really important question, and one that you're going to be keeping in the front of your mind throughout. What I think is most important is establishing a good relationship with your client, because your client's a child. They need to get to know you and to trust you before you can expect them to really divulge what their wishes are, what their objections are, what their experience has been, what their perspective is. And so typically at the Child's Advocate, we meet with each child client at least 3 times while we're representing that child. Some of those meetings are in person, some of them are remote. If we're in a case for a long time, then we'll meet with them, more times than 3. Where we have those meetings makes a big difference. We don't go to a client's home to have that meeting. We either meet in a neutral place like a McDonald's or a cafe or something like that, or we have the caregiver or the parent bring the child to our office. And we actually have a rule at the Child's Advocate that we let parents know about this ahead of time, but we ask them after they have dropped off their child to our office, we actually ask them to leave the building so that the child feels like they're in a space away from either parent, and we believe it gives them a greater degree of comfort that there's no danger they're going to be overheard.
One other piece of that I want to talk about is that because we take our directions from our clients need to be capable of stating what it is that they want and have the capacity to be able to do so. And so the ethics opinion talks about the need for the child to have the capacity to be able to direct the representation. And we have found that the child who is able to direct representation may be an older child with special needs. It could be a younger child. Traditionally, we have represented children who were 5 and up. And there are children who are older who may not be able to identify what it is that they want, but as long as our clients are able to state their perspective, then we're able to represent them.
And adding to what Atia said, if they're not able to direct the representation, then we do need to file a motion to withdraw if they don't have the capacity to actually, give us some form of direction. And one other point that I wanted to make about confidentiality and, where I conduct the meetings with my clients. So each time we meet with a child client, we remind them about confidentiality. We remind them of the fact that we're only going to share something if they specifically authorize us to do that. And so depending on the age of the child, we explain that with different terms. Sometimes we talk about our meeting, what they tell us being private. Sometimes we try to avoid the word secret, because obviously we don't want the child to think that they're being privy to secrets, because it can have all different types of connotations which aren't beneficial. But it can be quite funny to hear how a child may perceive the whole idea of confidentiality. I remember I had one, I think it was a 9-year-old boy, and he asked me, I had gone through the spiel about confidentiality, and then he turned to me and he said, "Will you pinky swear that you won't tell my mom I want to spend more time with my dad?" And so I pinky sweared. But sometimes, kids put it in their own terms.
Great, thank you so much. So, all right, let's say you met with your clients and you come out of the meeting believing that the client may be being coached. What do you do in that situation?
So, we've already talked about how to build trust with a client, and Suzanne talked about spending time getting to know your client, giving them a safe space by telling them about the confidentiality. The number of meetings that we have with our clients, all of this helps to establish the level of trust between us and the clients. In the 5.5 years that I've been at the Child's Advocate, it's been very rare. I can't even think of the time that I thought that a child was coached to the point that, let me back up. There have been times when my clients have appeared to not be clear in what they want. And so they do need more time in order to be able to articulate what they want. If there's a fear that they are being influenced by one of their parents, then I usually will schedule appointments and try to check in with the client and see if what they want has changed. If it has, I might ask them why it's changed and try to get a sense of what their reasons are, especially if it's something that is perhaps drastically opposed to what they had wanted before. If there's still a concern, I might talk to their therapist. I might talk to the therapist to ask how to approach the child, but also to see what the child is telling the therapist, if it's consistent. But again, this is very rare. It is the case usually that when we first meet with a client, they may be nervous, they don't know us, but as we get to know them and give them that sense of safety, they're more able to share with us what they want in their hearts, even if they don't then say you can, share that with others.
Thanks, Atia. Yeah, this is a subject near and dear to my heart, the whole issue of whether a child has been coached. Sometimes I often hear family law attorneys talking about, a child has been alienated, a child has been coached or influenced. I've had children come in. I had one girl come in and say, "I want a 5-2-2 schedule." She clearly had been told that by a parent that she needed to ask for that because, no 10-year-old child knows to ask for that schedule. But that was really, that was a detail. And it did not, as I, met with her throughout our meeting and explained to her and asked her, why did she want that? And, just got to know her a bit more. It wasn't an ongoing problem that she was being coached. But I guess even more importantly, we're not psychologists. We're not in a position to determine if a child has been coached. And bottom line, once we work with a child and we represent to them that we're going to advocate for their goals, we need to be really careful that we don't undercut them and undermine what they want by telling other people that we think we've got a client who's being coached. So for example, you might believe that you have a child who's been coached. You can't tell opposing counsel or counsel for the parents, I think my client has been coached by the other parent, because you would be breaching confidentiality. You only have any sense of a suspicion of coaching because you've spoken with your client. Also, you can't make a noisy withdrawal and signal to the court that the child is being coached, because again, you would leave the child in a much worse situation than if you had never been appointed, to represent them. I do want to touch briefly on a really interesting example with one of our pro bono attorneys who had a case a couple of years ago where she believed, after meeting with the child multiple times, that the child was heavily influenced by the mother and that the child was being influenced not to want to visit with dad. And after a while, it became clear to the pro bono attorney that she could still play a really useful role, because this child was at risk of having custody switched completely from mom to dad, because evidence was being presented about the excessive influence. But by having an attorney who was on his team, this child had somebody there to go to bat for him in court and to explain what was happening to the child. And so that's why it's just so important to keep any suspicions like that not to be shared with counsel for the parents.
And so it sounds like even with a suspicion, we still have the duty of loyalty and we need to be loyal to our client's position.
Absolutely, and not breach confidentiality or attorney-client privilege.
Thank you so much. Okay, so again, you've met with your client, you've spoken to them, you've come to understand what their wishes are, and you believe that your client wants something that is not in their best interest. In that situation, what do you do?
That question sometimes does come up. I would say in the 8 to 9 years I've been doing the work, it's come up maybe 5 or 10% of my cases where I don't think what the child wants is in the child's best interest. So how I first approach that is, well, first of all, I recognize that it's not my job to decide what's in the child's best interest. Who am I to decide what's in the child's best interest? But I'll counsel the child as to what to expect if we go to court, how a judge is likely to rule. But what's really important to remember is we mustn't we mustn't put a lot of pressure on the child to change their opinion. We shouldn't try and coax the child into changing their opinion to something we think is in the child's best interests. I've really come to learn over the years doing this work that children have a very good sense of what is best for them. And it really helps to guide my representation of the child, keeping that in mind, and that it's their experience and their perspective. They're in a much better position, to say that. So even if I don't think my client's wishes are in their best interest, I still advocate for my client's wishes in court. And one thing, I remember an attorney asking me at a presentation, well, is it okay to advance your client's goals on the one hand, and on the other hand, a kind of a wink to the judge? I don't really think this is best for the child. It's not okay, because that would completely undermine, our our zealous advocacy for our child client. We need to commit completely to putting on the evidence that supports what the child wants.
Yeah, I appreciate that. In particular, Rule 1.2, it tells us that there are certain things that are within our purview as attorneys, but essentially we have to take our direction from our clients. And I know it can be difficult as adults. We may think that because of a child's age that they don't have the ability or the sense. I was appointed to a case where opposing counsel tried to argue that what the child wanted was ice cream for dinner. In that particular case, what the child wanted was to have a shortened visitation period because he was unable to finish his homework. And he wanted to be able to finish his homework and then go to sleep. So he was actually, it was a very credible desire that he was expressing. And there's oftentimes some bias towards children. They're autonomous beings, and we try to respect them as such and to give credence to what their wishes are. It might not be something that we would have chosen for ourselves when we were children, but that doesn't mean that this particular child client doesn't have the right to make up their minds what they want. So yeah.
It sounds like one part of zealous advocacy is to really honor and respect the autonomy of our child clients. What about in a more extreme version? One question that we often get is, what do you do if your client wants something that actively puts them in danger? What do we do in that situation?
So there is guidance in a situation where a child wants something that would be harmful. An example is a child who wants to live with a parent who is in a home with an abuser, and the child is being exposed to that potential physical harm. And so the ABA standards, which we referenced before, and which I believe have been posted on the website for everyone, the ABA standards give us clear guidance, and our ethics opinion references it, that we are to, we have some choices, but mainly is to ask for a best interest attorney to be appointed to represent the child, to be able to speak to the court as to what they believe is in the child's best interest. And in this area, we don't typically have separate best interest attorneys, so it would probably be a guardian ad litem. And then we would still stay in our role, which is to represent to the court what the client's desires are, the client's wishes are, so that the child still has someone on their behalf reiterating to the court, even if the court doesn't make that decision as that being, what's in the child's best interest. So we definitely have steps we can take, and the rules help us do that as well.
And picking up from what Tia said, the language of the ABA rule on that issue is, if the child's attorney determines that pursuing the child's expressed objective would put the child at risk of substantial physical, financial, or other harm, and is not merely contrary to the lawyer's opinion of the child's interests, the lawyer may request appointment of a separate best interests attorney and continue to represent the child's expressed position. So, one thing to keep in mind in that context is it's a very, very rare occasion when we find that our child client wants something that puts the child at active risk. One thing I didn't bring up at the beginning is almost all of the cases that we're appointed to involve very difficult issues. There's often been a history of domestic violence. There may be either allegations or a history of child mistreatment or child abuse. There's oftentimes a history of substance abuse by a parent. There could be mental instability of a parent, a child with special needs, a whole host of things. But in terms of the factors that deal with safety, our overwhelming experience is that our child clients they choose something that makes them safe, as opposed to choosing something that puts them at risk of harm. So fortunately, it's an unusual experience for us to have to deal with a situation where we actually have to not withdraw from a case, but request the appointment of a GAL. I think in the years I've been at the Child's Advocate, we've done it on maybe 2, maximum 3 occasions.
The next thing I want to ask about is, as the child's attorney, we often will speak to third parties in the course of representation. How do you make sure that you are complying with your duty of loyalty to your client when interacting with those third parties?
So the duty of loyalty is a really interesting one, and you heard a TSA at the beginning that we owe our child clients an undivided duty of loyalty, just like we owe the same thing to our adult clients. Loyalty often involves maintaining confidentiality and respecting the attorney-client privilege. So sometimes in our cases, we get to work with parenting coordinators, and it can be a great opportunity because it can really help us to, bring the child's perspective to the attention of the parenting coordinator. But there can be a downside, not so much a downside, but we just need to be really careful that we're not sharing with the parenting coordinator confidential information. For example, sometimes a parenting coordinator is trying to figure out, I had a case maybe 3 years ago where my client, I think it was a 13-year-old boy, and he was beginning not to take calls from his dad. He wasn't wanting, no, it was a 13-year-old girl. She wasn't wanting to take calls from her mom. She was living with her dad. The PC couldn't figure out whether it was the other parent who was influencing the child not to want to take the calls, or whether this was something coming directly from the child. And so the PC was trying to find out from us or from me, which it was. I couldn't share that information. I knew from my client, it was coming from the client directly. It wasn't anything to do with the other parent. But I couldn't share that information with the parenting coordinator without getting authorization from my client. Because obviously, if I reveal something to the parenting coordinator, then it could put the child in a lot of trouble with one parent. So that's one area where the duty of loyalty is super important. Another area is like if a custodial evaluation is being done, sometimes the evaluator may reach out to you and want to talk to you about your client. And it can be a great opportunity to let the evaluator know what your client's wishes are and what they would like to see happen. You just need to be careful that whatever you tell the custodial evaluator is consistent with what your client would authorize you to share, because whatever you say to the evaluator may well end up in the custody evaluation report. And so you want to make sure that you're remaining consistent with the child's position in that situation. Also, you also don't want to end up as a witness, so it is important to let the evaluator know that you are an attorney and your role is to advocate in court, but you can share what the child's wishes are.
We keep coming back to duty of loyalty because it is such an important concept, along with confidentiality. And as you said, we don't want to undermine our child client's credibility or their position. I don't believe that everything that every client tells me is true all the time. I don't believe, but I also don't disbelieve everything that my clients say is true just because they're children. And I think that's important for us to remember, that part of our duty of loyalty is to credit what the clients are saying And in the years that I've been here, I don't know that I've had any evidence of my clients lying to me. So it's important to remember that if it does happen, it's a rare thing and we can't share it with other people.
And it was interesting, you know, people often ask us questions like, well, you know, how do you know the child isn't lying? I like to turn that question back to parents' attorneys. You know, parents lie sometimes, and they sometimes lie in court. And so, you know, with children, yes, I'm sure some of my child clients have told me, you know, some small lies, but I've never had a case where there was complete, you know, such complete lies that it totally undermined what they wanted. You know, sometimes children may not disclose everything, and that is, you know, that's a separate issue from being intentionally deceptive. And I think Atia and I share the same experience that children tend to be quite honest. It is what we find. And from talking with psychologists, we work closely with children's mental health providers. Children don't typically lie. I mean, there are developmental stages where they may you know, tell small lies because they don't want to get into trouble, or they're embarrassed, or they feel guilty about something. But by and large, children tend to be pretty honest within the context of the relationship that we have with them, has been our experience.
Thank you. So now I'd like to shift to gears to a different kind of question. So, you know, in preparing for hearing and everything, what happens if you receive a subpoena for your records?
So like if a parent's attorney issues a subpoena, well, sometimes and most often, usually the problem is the parent's attorney doesn't understand our role. They think we're a guardian ad litem. And so, you know, it's perfectly appropriate to issue a subpoena for records from a guardian ad litem. Usually I will first request that the attorney withdraw the subpoena after I've explained my role. And I know a number of our pro bono attorneys have had that issue come up. It's not an unusual one, but typically the attorney issuing the subpoena is willing to withdraw it once it becomes clear that we are in a traditional attorney-client relationship with our client, and all of our records of our meetings with our clients, all of that is covered either by the privilege or by work product, and so it's not subject to being turned over to counsel for the parties.
And in a similar way, if we are asked to testify, you know, the example, if we're given a subpoena, I find this happens sometimes in court, you know, without a subpoena, that sometimes I've had attorneys try to call me to the witness stand, and I have to emphasize that I am not there and I cannot stand as a witness in the case, because then I would not be able to represent my child's client. And this is another place where Rule 3.7 makes it really clear, lawyer as witness, and how that could potentially harm our client's position and the ability for us to be zealous advocates. And so we go back to, and I will continually say, you know, I'm not able to testify. I don't write a report. I'm not making a recommendation. I behave in the courtroom the same as the other attorneys, and I will be able to put on evidence and to question witnesses. I can't do that and be effective if I'm the witness. So.
And I think I know Atia regularly identifies in court, you know, what role she is playing, and I'm starting to do it more. I mean, I have done it in the past, but I haven't done it on every case basis. I think it's a really good way of, especially with a new judge or attorneys who haven't worked with a child's advocate before, to really make clear what our role is. You know, and sometimes I've been asked to make recommendations just in the context of trying to promote a settlement. And we often do try to get the parties to settle in our role as child's advocate, as long as the settlement is consistent with, you know, the child's position. But we're not like a GAL with any authority to make a recommendation, or a parenting coordinator with the authority to make a directive. We don't have that kind of authority. So when we're asked for recommendations, we'd like to make that clear. I mean, sometimes, you know, the line is blurred between what we're saying we'd like to see happen versus making a recommendation.
Sounds like being clear on our role as the child's attorney is absolutely key in those situations.
Yes.
And I imagine for the pro bono attorneys, they might face the same situation, that then they would want to be in the position of reminding the court or the other attorneys what their role is as well, to make it very clear for everyone in the courtroom.
Thank you. So as your representation is progressing, how do you ensure that your client stays informed about what's going on in the case?
Who is this? I'll go ahead. So keeping our clients informed. This is an interesting question, because children are very, very different from adults in this respect. We're very lucky. We don't have our child clients emailing us, texting us, calling our office all the time. In fact, sometimes we have not the opposite problem, but we need to reach out and initiate contact with our child clients. We found that we can't expect them necessarily to initiate contact. Occasionally they will, but much of the time they're not really confident enough to do that. It's just harder for a young child, you know, or even a teenager to reach out. So what I typically do is, if a child has a cell phone, I'll text the child and I'll say, can you talk for a few minutes tonight? I just want to update you. And I'll kind of keep the child informed as to what's going on. If there's been a significant development that the child needs to be made aware of, by no means do I provide the same level of detail and information that I would to an adult client. You know, I tailor the information I give to the child's developmental stage, to the interest that the child has in knowing this information. Sometimes this information is really stressful and they may prefer, you know, not to be constantly updated. At the time when we withdraw from representation because a permanent custody order has been entered, we make sure that we have a final meeting with the client, and that we explain this is our last meeting, and that, you know, that this order is now in effect, and this is what will happen under the order, so that the child understands going forward how things are going to be, and what may have changed for them, whether or not they have gotten the outcome, at least in part, of what they hope to get. And so we don't like to just let our child clients just hang out there without being told, you know, that the case is now concluded.
And I guess one other point I will make is that children tend to have a different sense of time than we do. And so it makes sense. Doesn't mean, as you said, that we have to keep them in constant communication with us. But if we say that we're going to do something, that we respond and help them to set their expectations so that they're not waiting on us. And because I believe that it still may be that the lack of communication is one of the #1 complaints to the state bar, even for adult clients, it's even more important for us to keep in mind the need to keep in communication with our clients. So that's important for children as well.
And related to the whole issue of updating our clients, because they are children, they're often using cell phones where a parent pays for the phone, or they're using email accounts where the parents are able to monitor the accounts. So we make sure that we don't put confidential or privileged information into either an email or a text, and that we only share that information with them in person.
Okay. Now, on occasion when we have cases appointed, sometimes you're appointed to represent siblings. In those situations, if it turns out that the siblings want different outcomes or have different goals for the case, what do you do?
And that's yours.
Yes, yeah. So it's one of those things where we need to make sure that it's a different position that's actually going to affect our ability to represent them effectively. So I had a case, I still have a case now, but I have a case with one child wanted to relocate and the other child wanted to stay here. And I was able to represent both of those positions at the same time. There are times though when there would actually be a legal conflict, if you will, between what the siblings want that would then lead us to have to take other steps. And an example is if a child wants to stay with a parent and then the other child doesn't want to be with that parent because of some wrongdoing or something, it would be impossible to put on the evidence of the parent's wrongdoing without then undermining the other child's position. And so in that case, we would have to do something different. And will you tell us a little bit more about what we do in those cases?
Sure. So, and this has happened several times in recent years, where one attorney may be appointed to representing 2, maybe even 3 children, and it transpires during the course of the representation that one child may have a position that it would be really impossible to advocate for effectively at the same time as representing the positions of the other 2 children. Excuse me, because of that duty of undivided loyalty, we wouldn't be able to fulfill that duty to all 3 children. So when that happens, we will try to find a pro bono attorney to represent, say in that case, to represent the child whose position really couldn't be advocated for effectively at the same time as representing the other 2 children. And so it's really helpful to have pro bono attorneys available in situations like that particularly. And so we actually also have some cases where judges appoint separate TCAs to siblings from the same family from the very beginning, because it's apparent that the siblings may have very, very different positions. And really, I think where the primary conflict is, there just wouldn't be the ability to fulfill that duty of undivided loyalty and the duty of zealous advocacy for each of the children.
And as you said, another reason why we really like our volunteers, because we need them to help us in those cases as well.
Finally, throughout this conversation, we continue to return to the importance of being clear on what our role is as children's attorneys. Have either of you ever had a case where the presiding judge asked you to do something that falls outside your role as the child's attorney? And how did you handle that situation?
I personally have not, but I do know of another attorney. This was many years ago. It was really before our role was completely clear, certainly in Wake County. And then an attorney was asked to do almost like a home visit and to let the court know what the conditions were, that kind of thing. And so should that happen to you, and I think it's unlikely that it would, just make it clear that you can't do a home visit in the way that a guardian ad litem would do a home visit. Now, there's nothing to prevent you from going to visit your client and maybe a relative at somebody's home just to watch see the kids together, something like that, just to get a better understanding of your client's perspective, but not the kind of home visit where you're, you know, opening up the fridge, checking their cupboards to see if there's food, if the place is clean. That's not within our role.
Okay. All right. Thank you so much. I think now that we can open it up to audience questions, if there are any.
Okay, we do have a couple of questions that have come through while you were speaking today. Someone asked if there's discovery propounded in the divorce action. Actually, I'm going to unshare the screen so they can see you better while we're doing this. Here we go. So if there's discovery propounded in the divorce action, are the child advocates provided with the responses or included in attendance at any depositions?
Great question. Our appointment order allows us to have access to any information related to our clients. So for example, if an attorney has subpoenaed hospital records for a child or they've been exchanged in discovery, then yes, we are entitled to have access to that information. And I'm sorry, Sandy, what was the second part of that question?
Whether, yeah, are you in attendance at the depositions?
We are. We're typically noticed on all depositions because our appointment order requires counsel for the parents to serve us with all of the documents in the case. And so we do make it a point, you know, sometimes there are exceptions, but generally we make it a point to attend a deposition, because invariably, if it's a deposition where the topic of custody and visitation is going to be discussed, then we definitely want to be there.
So a similar question, if there's a settlement, does the child advocate have a role in negotiating a settlement?
Before I answer that, I want to go back to, and I don't know that this was said, although we participate in depositions and we receive the discovery, we don't actually conduct discovery ourselves. And so we're not noticing parties for deposition, but we would attend. And with settlement, our appointment order states that any settlement agreement has to be approved by us before it can be presented to the court. What we've found is that it is very difficult for us to come behind the settlement and try to get our clients on board. And so the best thing for us and also for the parties is for us to be involved in the settlement negotiations. And we often, just like with adults, we'll talk to our clients about a range of possibilities and see what it is that they would be willing to agree to. And then we represent our client's position in that way as well. And then there have been other times when I have been at the courthouse talking with the parents' attorneys and we're trying to work something out. And then we'll get my client on the phone and have my client, and I will get my client on the phone to talk to my client about what my client wants. So even in settlement, I still have to go back to my client since the client is directing representation.
And I'd say, so I would agree with everything Atia said, and we often play a major role in facilitating a settlement. I think it's an area where we can be very useful, especially in cases, you know, that have these very serious issues, children with special needs, history of child mistreatment, exposure to domestic violence, mental instability of a parent. I think the child's advocate it can effectively facilitate settlement a lot of the time, not always. We do try some of our cases.
Someone asked what the ages of your clients are. Are your clients testifying? And if so, what age range are they?
So we rarely have our child clients testify. And so a couple of different points there. If a child really wants to testify, which is unusual, but sometimes we have a client who really wants to talk to the judge, if there's a good reason to have the child talk to the judge, and we really can't get that information, that evidence presented through any other route, then we will see if we can get the parents' attorneys to agree that the child goes into chambers with the judge, with the attorneys present, and talks with the judge there. It's very, very rare for us to put a child on the stand to testify. I think I've done it once in all the years that I've been doing this, and that was during COVID, and it was remote testimony by a child who was 15. But you know, short of that kind of the kind of circumstances involved there, we try to avoid having children testify. But it can be very empowering for them in cases where it's appropriate and they want to.
Yeah, and I will add to that I would say the number of times that I have my clients go to court to testify is pretty equal to the number of times that one of the parents' attorneys calls my client to testify. And so I'm preparing my client to testify based on the fact that someone else is calling them, not that I'm independently calling them. So that's also one of the times that we will be involved if the judge is aware that one of the parties is going to call the child to testify. They will usually appoint us so that we can represent the child's interest in that setting as well. And then in terms of the age, I wasn't sure if the person was asking the age of appointment or just the age of a child testifying.
It sounded like the age of someone testifying.
Sorry, go ahead. I have never had a child younger than 11 talk to a judge in chambers. More often, they have been a little bit older than that. But I know over the years, other attorneys at the Child's Advocate may have had slightly younger children need to talk with the judge. But it's definitely an exception in our cases for the child to actually have to testify. What happens much more often, like what Atia was touching on, is one of the parents is planning on having the child testify, and the judge wants to make sure that that child is prepared, has an advocate who can give the arguments as to why the child shouldn't have to, or if the child wants to and there's good reason for it, prepare the child for what to expect and be there sitting beside the child during that process.
So someone else asked, can you speak to this? Many custody orders contain provisions designed to insulate children from knowledge or information about the litigation. Yet our role as child advocates, pro bono attorneys, involve them directly in the process, and we have a duty to keep them informed. How do we best balance those competing interests?
So very often, and I don't know what is in the judge's head, but I imagine that what they want is for the children not to receive the emotion that is often attached when parents are telling them about litigation. We are representing the child's position, and we are there to, in a less emotional way, share with our clients what is going on. And it seems to be, and we've talked to therapists about this, I believe, it seems to be helpful for the children to have information in a way that is not alarming. But so being able to give them information, I think, is helpful, especially because we, as was said earlier, we work on developing a relationship with a child, and so they are trusting us, and so we are, we don't have a dog in the fight, if you will, in terms of the way that we share the information. We're telling the child because our interests are with them. So I think that is the way to balance it, is that we are not there advocating on the parents' behalf, we're there on the child's behalf. And so I think that distinguishes how we present the information.
I love that question. it's so interesting to me that, you know, most custody orders, as the attendee noted, you know, has a provision in there about the parents are not to discuss the litigation with the children. And I mean, I fully understand the reasons why the judges say it, but it can create a false impression that somehow by putting in an order that parents aren't to discuss it, that the children are somehow insulated. All of the children we represent, they are so much in the middle of the litigation. They are so aware of what's going on, but oftentimes they don't have an accurate sense of what's going on. They've either been given way too little information or way too much information. And so, you know, a huge part of our role as children's advocates and attorneys is to distill what the client really needs to know or wants to know. We don't get into we get into very little detail with our clients by comparison with you know, all of the information we would provide if we were representing an adult client. But I think the biggest thing that I've learned doing this work is these children are so much in the middle already. We don't put them further in the middle. We actually help to insulate them by providing information in a less emotional, fraught manner than their parents would.
Thank you. Someone asked if you've received, and I apologize for not knowing what these acronyms mean. Have you received RPDs or ROGs or admissions as the TCA for the child to respond to? So is that more discovery?
Yeah. That is more discovery.
So I have in one case, and I was explaining that we don't respond to discovery, and before we could really get down the road as to whether or not we were able to settle the matter. So I don't know if you want to speak more to.
We're not a party. I mean, the child is not a party to the litigation. So we do not serve discovery on the child's behalf, and we do not respond to discovery on the child's behalf. So yeah, I hope that answers the question.
Except for subpoenas. We can issue subpoenas and our clients have to respond to subpoenas. So
that's correct.
So I was wondering how long, if you're working as a pro bono attorney with your program and you take on a case, what kind of time commitment is that from start to finish?
I would say on average, it ranges between 15 hours and 30 to 40 hours over the course of maybe a year, 6 months to 18 months. You know, in Wake County, our cases go on a long time, so the time might be incremental over the course of that time. I would say 15 hours is the lower end, since we really encourage attorneys to talk multiple times with their clients, also to talk with each of the parents, to consult with the therapist. And then if the case goes to trial, you know, that's going to take some time, but many of the cases do settle. So I think that's a realistic estimate, 15 hours to 30 to 40 being on the longer side. You know, we have had pro bono attorneys who have just done incredible work and literally put like 80 hours into a case and just done, you know, gone above and beyond, but that's not the typical amount of hours. So don't think you're going to be sinking those kind of hours into a case.
And also, I imagine that's over some years. It's not.
It was 1 year.
Yeah. Okay. And in Durham, the cases tend to move a little faster, and there's tend to be shorter court hearings, and so I would say it's probably closer to 15 to 20 hours.
Great, thank you all so much. I think we've covered all of the questions that we've received. We are exactly at 2 o'clock, so that is very impressive timing as well. And we really appreciate you coming in and speaking to us all today. Thank you so much. I will distribute, because I know on the last slide that I didn't share has information about volunteering. It has forms that you can fill out if you want more information. I will send that all along with the attendance reminder that comes out later this afternoon. And if you want more information, I can give you contact information for our speakers today as well.
That would be great.
So thank you
so much,
everyone who
Cindy.
attended. We've got some great comments already from people who are attending saying thank you. This is a wonderful presentation.
And just as a quick reminder, March 30th is our training for experienced family law attorneys, and the PowerPoint, which also has our contact information, will be posted on the website along with the other materials. And we thank the Wake County Bar Association for sponsoring this and supporting us. And we really do need volunteers. So we hope that people will come and join us on March 30th. And if you can't come that day, then we're happy to send you the training materials so you can be trained on your own time.
And where is that training?
It will be at Pointer School in Raleigh.
Okay.
From 2 to 7 o'clock, and there will be food, and there will be judges panel, and there'll be great presentations.
Excellent. We'll get that information to everyone as well. Thank you so much.
Thank you.
Thank you very much.
I can stop the recording.